Hello viewers of SSBC, thank you so much for joining us from wherever you're tuning in. We're coming to you live from Juba with the latest development in the country that is regarding the court proceeding that is going to be broadcast to you live as we are right now in the studio, and our team are down on the ground that will be making sure that this very important event in our history of the country to ensure justice prevail has to be given very top priority. On 22nd of September 2025, of course, will not only remain a turning point in the judicial and legal system of the country, but also shaping the rule of law and justice system in the country. As finally the court proceedings and trial of the accused Dr. Riek Machar Teny and 7 other Splm IO and top military leaders and political leaders commences in a short while, as we are live to you from Juba, as well as our team is also down on the ground at Freedom Hall, and they will be relaying this event to you right away from the commencement, from the arrival of the accused and the arrival of the defending lawyers, as well as the government team, as well as judges. Of course, this event will be presided over by 3 top judges of the country who are qualified and well, equipped with the country's rule of law, and they will ensure that justice prevail. Of course, viewers, we have our reporters down on the ground who will be giving us an update on what is happening. We have Leila Osman, Mori, and we have also Martin Justin Kose. These are some of the top, SSBC reporters that we actually put on the ground to ensure they connect us to the reliable, individuals and judges as the proceedings commences in a short while. And of course, we're expecting the arrival of the team shortly. They will be at the Freedom Hall, and then we will commence you or connect you direct to Freedom Hall. The genesis or background of this event, it is something of national, interest that the country and the leadership of this nation has to ensure that normally justice prevail where it is necessary. And back in the days, that is the genesis of the court proceeding of today. Of course, all it started due to the culmination of the Nasir incident. All of you can remember that on 3rd of March 2025, when the militia, known as White Army, they actually went and attacked, launched an offensive coordinated military and an attack to South Sudan Defense Forces, SSPDF, back in the days, that is in Nasir in March, resulting to the killing of Major General. Of course, all of us are well aware about him. That is General David Dakmajur, and as well as number of SSPDF soldiers killed, above 200, more than 200, and the United Nations pilot also during that event, who was sent to do the evacuation, also got killed on the ground. According to the government investigation team and the intelligence indicating that the white militia were actually not acting on their own, but acting on some of the directives from the IO leaders, of which this all resulted to what we are witnessing today. And of course, on 26th of March, the government took proactive measures to ensure that law prevail in the country by ensuring that Dr. Riek Machar, along with other top IO political leaders and military, were actually being apprehended. And this resulted to the detention of Dr. Riek Machar under house arrest, as well as 7 others. Of course, the people who will appear and pay or listen to what is happening, and those who will be able to defend themselves based on the cases and charges that the government and being put on them. This include none other than Potkang Chol, the suspended Minister of Petroleum. He will be part and parcel of that court hearing or court proceeding at Freedom Hall. And then we have LT General, Lieutenant General Gabriel Doplam. We have Mom Pal Dor. We have Gadwich Lampoj, and we have Brigadier General Camilo Gatmai, and then Mading Riak Yak, as well as Dominic Gatcock Riek. Some of these individuals, according to the government, these are the people who will appear and answer to some of the charges that are leveled against them. And these charges were read out previously by the Minister of Justice, that is Honorable Geng. He has made it clearly that these are some of the charges that put these people to where it is today, and they have to be answerable to whatever that happened during Nasir incident. As I have given you the background that this all culminated due to the incident that happened in Nasir, resulting to the killing of Major General, as well as more than 290 SSPDF soldiers were actually killed. So we're going to say that, of course, there is a defending lawyers that are actually going to defend the accused. That is a company known as Cour Company Advocate and Law Firm are going to be. So we're going to connect you viewers to Freedom Hall, and let's hear from our reporters as well as the proceeding take place. Stay tuned with us as we relay you back to Freedom Hall. And back to our reporters in Freedom Hall, let's get to hear what is happening in the court proceeding of Dr. Riek Machar and 7 other accused.
Yeah, the detained suspended first Vice President of South Sudan. Today marks the first day of the trial case that is being closely followed both nationally and internationally due to its high significant political and legal implication. As a reminder, Dr. Machar stands accused of supporting terrorism, damages of property, among other issues, as we will continue following depending on the legal proceeding in the court at Freedom Hall. I hand you over to my colleague, Mathiang.
Good morning, everybody, and thank you, Leila, for the opportunity. Now we are at Freedom Hall, the opening of the trial of the opposition leader, the suspended First Vice President Dr. Riek Machar Teny. He has already arrived at the venue to face charges. This is the first time in the history of the country to have this high-profile case against opposition leader. Dr. Riek Machar was detained, arrested in March after fighting erupted in Nasir. He has been accused of supporting and planning treason, murder, and conspiracy against the government. And under Chapter 5 of the Transitional Justice in the Peace Agreement, nobody's the individual, whether you are holding a high-profile position, you should not really involve in supporting violent activities, trying to overthrow the government, or planning against the transitional government. Now the court, this is a special court being handled, and the number of the judges is not yet disclosed. We're still waiting for the final hearing, the commencement of the case. We're just giving you some highlights about this case here happening at Freedom Hall. We shall give you more updates about this hearing. Already the accused are already at the venue. They are waiting for the presentation from the selected judges, in which their number is not yet disclosed to the public. But if the number is disclosed, we shall be able now to give you the updates. We have 8 accused: Dr. Riek Machar Teny, Podkang Chwal, Lieutenant General Gabriel Duablam, Brigadier General Camilo Gat Manch, Madingyak Riek, Dominic Gadkok Riek, Gadwich Lam Poch, and Mampal Duop. These are the accused that are going to face some trials, the opening of the trial of this high-profile case in the country. This is a test of the country's justice system and being backed up by the transitional justice already being implemented in the revitalized peace agreement. More of these are coming. Back to the studio. Gore Anthony in the studio will be talking more about this.
نعم، تحية طيبة لكل مشاهدي ومستمعي SSBC في كل مكان. نحن الآن في بث مباشر من قاعة الحرية بجوبا، حيث الجلسة الأولى أي جلسة الاستماع لمحاكمة دكتور رياك مachar النائب الأول لرئيس الجمهورية الموقوف، وأيضا معه 7 من المتهمين. يواجه هؤلاء المتهمين تهم تتعلق بالإرهاب وتمويل الأعمال الإرهابية، وأيضا تدمير المرافق والمنشآت العامة والعسكرية. نعم، هؤلاء يعني في تحول ديمقراطي يتميز به من الآن، يسجل في تاريخ جنوب السودان أن أبرز قيادات الدولة يتم محاكمتهم في محاكمة عادلة ويشهد عليه جميع العالم. من أبرز المتهمين 8 ذكره زميل ماتيانغ هم دكتور رياك مachar تيني، أيضا الفريق جابرييل غاتويج لامبوتش، عندنا بال كان تشول وزير البترول، وعندنا مام بال دوت، عندنا أيضا برغادير جنرال كاميليو غاتماي كيل، وأيضا مدين ياك رياك، وعندنا دومينيك غادغوك رياك. هؤلاء المتهمين 8 سيواجهون التهم السابقة، ويعني في بث مباشر عبر قنوات SSBC الإذاعية والتلفزيونية، ويعني كشاهد عيان لهذه المحاكمة العادلة وتمثيل لديمقراطية جنوب السودان. الآن نعود الاستديوهاتنا الرئيسية في نيوكورن والزميل غوري أنتوني، ونتابع معكم المزيد.
Proceeding, of course, taking place.
Thank you
currently
so
at,
much, Martin
at Freedom Hall. And from what you have received from our, reporters on the ground, in the names of Mathiang Joseph and Martin Justin Kose, they have managed to highlight some of the some of the things that are happening on the ground. We've seen that the 8 accused have already arrived, starting with Dr. Riek Machar Teny. He's on the ground currently, as some of you might have seen him while we are, relaying to you this. We have also Potkang, the suspended Minister of Petroleum. He also on the ground. We have also Lieutenant General Gabriel Doplam. He's also on the ground. We have Mompal. He also came as one of the accused. We have Gadwich Lampoch. He's at Freedom Hall currently. We have Brigadier General Camilo Gatmai, and some of you might have seen him as well. Then we have Mading Riak Yak, then Dominic Gatkoth, then Riak. So these are some of the accused in this very special court that you've seen being organized by the government and the judicial system of the country. Of course, like the saying always goes that nobody is above the law. And therefore, as we wait for the presiding judges, which my colleague Mathiang Joseph made it clear that up to now, we haven't got the detailed names of the presiding judges who will be taking over this event or taking over this trial or court hearing. Then we'll also, as well as in the beginning, I told you that there is the defending lawyers of Dr. Riek Machar and the 7 other accused. This is Mr. Kur and company advocate who are being hired by the family as well as members of their IO group to ensure that they defend, because any accused in the court has to proven innocent until all the lawyers and judges and the defendant has to be able to prove that their clients are innocent or guilty. Therefore, this court proceeding will be continuing, and as I said in the beginning, that This event that resulted to today's court hearing, it's due to the Nasir incident that happened. And of course, during that day, a lot of lives were lost, so many lives were lost. And the country also lost Major General. And of course, according to government data and intelligence, that the White Army militia did not actually acted on their own, but there were some people behind this directing them or giving them directives. And this resulted to the charges that previously read by Honorable Joseph Geng, who is the Minister of Justice, and most of you may have heard these charges. And these charges are what is going to be put on the table today to ensure that they defend themselves. The defendant or the accused has to actually tell their side of the story. These are two sides of the story now. So it depends on the accused and their lawyers to prove themselves on the charges. And this is why always court is put in place to ensure that the two sides come together, they air out the charges, and then they respond to what is happening. And viewers, of course, as we said, for purpose of transparency and purpose of ensuring that rule of law take its course in this country, this is how the national government or the unity government is started. And I'm sure this will not remain only with these 7 accused. Of course, the government always will ensure that from henceforth, people will be accountable for whatever they did. And back to some of the charges that were labeled or leveled against the 7 accused that we have mentioned, led by high profile, that is Dr. Riek Machar. According to the Ministry of Justice and Constitutional Affairs, and this statement was read previously by the minister himself, the charges filed against the accused are all heavy capital offense. This include treason and act against the state authority. We have murder, then conspiracy and common intention. We have terrorism financing and finance terrorist act. We have destructions of public property and military assets. Then we have crime against humanity, in brackets, systematic attack on the civilians and ethnic-based persecution. Based on these charges, this will actually be the lead where the top judges of the country will be able to preside over this, allowing also the defendant or allowing the accused with their lawyers to be able to respond. Of course, court proceeding takes a while, so it's going to take some time for us to know where this case will end. But of course, always there is an end for everything until justice prevails. The company, of course, which is hired is Kur and Advocate Law Firm, which is actually taking over and standing in between to ensure that they defend the accused. The essence of rule of law, of course, has always been said, essence of rule of law is that all people and institutions within the political body are subjected to the laws. This concept sometimes is stated simply that no one is above the law and all are equal before the law. Therefore, this is a step that the government has taken to ensure that people are subjected to the rule of law. Being subject to rule of law is that you need to adhere and work in line with the rule of law of the country. The government has given top priority to this event because it is something that is very important, and therefore we will be actually telling you or showing you whatever is happening and keep you updated. So back still to our colleague, as we have seen at Freedom Hall, most of the accused arrived. So let's get a few updates from my colleague on the ground, Matiang Joseph and Martin Justin Kose, who are giving us more update and highlight of what is happening currently at Freedom Hall. Let's get a break. Let's get a quick view from my colleague at Freedom Hall as we continue to relay or broadcast to you this live. Matiang Joseph and Martin Justin Kose, over to you, my colleagues.
أبرزهم وزير البترول بوتكانغ وجنرال جاتويج. ويعني هذه المحاكمة جاءت نتيجة التحقيق أو لجنة التحقيق اللي تمت بعد أحداث ناصر اللي حصلت في مارس من هذا العام، ويعني أدى لمقتل تلك الأحداث أدت لمقتل أكثر من 250 جنديا وتدمير ممتلكات حكومية وعسكرية. ومن الذين لقوا حتفهم في ذلك الأحداث هو سعادة اللواء ماجور داك. ويعني بعد إجراء التحقيق الشامل حول هذه القضية أثبت يعني أظهرت أو ملابسات هذه الحادثة يتعلق بالنائب الأول وهؤلاء المتهمين السبعة اللي الآن هم موجودين داخل قاعة المحاكمة. وهذه المحاكمة يشرف عليه ما يعرف بالمحكمة الخاصة. هذه المحكمة الخاصة يتكون من 3 قضاة، وهؤلاء القضاة لم يتم ذكر أسمائهم، فقط ننتظر حينما يأتوا للقاعة ويعني يظهروا أو يعرفوا الناس بأنفسهم، بعد ذلك يمكننا أن نعرف من هم هؤلاء القضاة. ويعني من أيضا أسماء من هم مسؤولين من الدفاع عن جانب الحكومة لم يذكر أسمائهم أيضا، ولكن نعرف حسب التقارير الإعلامية اللي مصاحبة لهذه التغطية لفترات سابقة، نجد أن المسؤول من يعني الدفاع عن المتهمين هو أحد الجنوبيين المشهورين في الدفاع أو الهيئة القضائية، وهو المحامي كورلوال. أيضا يعني يسعدنا أن نذكر أيضا أن أسر المتهمين الآن هم موجودين داخل القاعة، ومن أبرزهم وزيرة الداخلية أنجلينا تاني، وهي أيضا ضمن يعني لم يكن في المتهمين ولكنها موجودة الآن ربما لتؤازر أو لتساند زوجها دكتور رياك مachar. الآن أيها المستمعون والمشاهدون الكرام في كل مكان، تابعوا SSBC في نقل مباشر وحصري ولمعرفة ملابسات أو إجراءات هذه المحاكمة. والآن نحن في مواصلة لعرض ما يحدث في المحكمة. الآن يظهر أمامنا زوجة دكتور رياك مachar أنجلينا تاني. والآن نعود للاستديوهات الرئيسية في نعم حسب الإجراءات ما زلنا نواصل معكم من داخل قاعة الحرية، ونعيد المايك للزملاء ماثيانغ وليلى وبيتر موري جيمس.
Thank you, Martin Justin Coste for the mic. Continuing with our moderation at Freedom Hall, the opening trial against Dr. Riek Machar Teny and his associates not yet commenced. We shall get more information details when the program commences. The proceedings have not yet started. But now to give you highlights about what is happening in the courtroom. This is a special court being spearheaded by the country's judiciary. This is following the investigation from the Nasser investigation accusing Dr. Riek Machar Teny and others for treason, conspiracy, murder after fighting erupted in Nasser in March this year, killing more than 250 soldiers, SSPDF soldiers, and General Maju Dak. And it is being indicated in the Chapter 5 of the Transitional Justice in the Peace Agreement. Individual involved in treason, conspiracy against a coalition government will face justice, and also they are accorded fair trial and avoiding the arbitrary detention They are also accorded rights to defense. Now in the courtroom, we have a legal team sitting in one corridor, the prosecution team in the corridor, and the defense lawyers sitting in the corridor. And the atmosphere is quite calm, and people are waiting for the commencement, as already the accused are inside the courtroom, as you can see. The family is sitting in their corridor, and the government figures in the coalition government from the IO. We have the Minister of Interior, Engineer Teny, sitting alongside the family of the accused, including former Speaker of the Council of Estates, Deng Akon, in the courtroom. Already Minister of Justice and Constitutional Affairs, Dr. Joseph Gangakech, in the courtroom, and the proceedings are about to commence as everything is set. We have SSBC inside, the only media outlets covering this hearing until the end. So we shall be updating you about these proceedings, legal proceedings, commenced on Monday. The first time in the history of the country having these legal, having the trial against the Okay, now you can see the two legal team are greeting themselves. They are showing that the chemistry is really vibrant. They are laughing, they are greeting each other. The defense team and the prosecution team are greeting themselves. Quite of a reminder that this is all about testing the country's justice system. You know, nobody is above the law, and everyone is expected to respect the country's constitution. This is not about targeting, but it is kind of testing the constitution of the country against anybody trying to suspend, sabotage the coalition government, the transitional period. Now, for the meantime, I'll give the microphone to my colleague Leila Usman to give you more updates about these proceedings, which have not yet started.
Thank you, Martin Joseph, for the highlight. Actually, as a reminder again, Dr. Riek Machar stands accused of supporting terrorism, damages of properties, among other allegations, as we await for more proceedings from the judgment. He is stand accused, but not until proven guilty by the courts of law. This legal proceeding is a test not only on the strength of the judicial system of South Sudan, but also the country's commitment to democracy and the legal norms. This is the first legal proceeding taken by the High Court of South Sudan, so the whole world and the whole country is awaiting to see the processes. We'll keep updating you. Please stay tuned with SSBC for more details. The court proceeding has not yet begun. The judges are already in place, and we are still waiting for confirmation of the legal and numbers of the judges. Then and other practitioners will give you more details on that based on incoming events. Thank you. Martin, over.
Okay. Thank you, Leila Osman. Before I give it to my colleague Peter Mori, I would like to bring to your attention that the proceedings have not yet started. We shall hear more testimonies, more evidence about this case, because the judges will now be able to present the testimonies, evidence regarding this case against opposition leader Dr. Riek Machar Teny and his associates, including Petroleum Minister Port Kang Shual. And when the proceedings commenced, they will be able now to give more evidence, and the defense team will be able now to present their objections against, the prosecution team if the evidence are still lacking. But now we cannot conclude by saying that, because the proceedings have not yet started. We shall get more details when the program is started, whereby we shall be seeing judges the official judges managing this trial against the suspended first Vice President Dr. Riek Machar Teny. We have no more things to talk about, but it's all about the hearing, when things are happening this way is another way of saying that the coalition government is committed to stability, security, whereby anybody trying to sabotage or to cause commotion or chaotic environment, the law stands against anybody trying to destabilize the country. It's another way of telling the public, the citizens, that it is significant for the country to stay stable. Now we are going to the studio where Gori Anthony will be talking more about these proceedings as preparations are ongoing. When we come back, we shall tell you the commencement of the hearing. Thank you.
Yes, that was my colleague Mathiang Joseph and Leila Osman. We have Mori, plus Martin Justin Kose giving an update on what is happening at Freedom Hall. As you people have seen, and our viewers all over, plus members of diplomatic corps, I'm sure most of them are now following us, wanted to see exactly what is happening and what is the next move after this court. And this is the question that is lingering on the mind of everyone, that what next? From here, of course, until the accused are proven guilty. But up to where we are now, it is right now where the court hearing will start. And it will start as soon as the presiding over judges, they have already arrived. There's some bit of arrangement that they are coordinating to ensure the commencement of the event at Freedom Hall. Of course, the saying goes, justice in 3 words: the quality of being just, impartial, and fair. In another word, fair, open, and impartial. And this is the guiding principles of rule of law that will take place from today. As you've seen, of course, we have seen the family members of the accused are already at Freedom Hall. They are there to give a support to their family members. You've seen Dr. Riek Machar, you've seen Honorable Potkang, you've seen also Lieutenant General Doplam, you've seen also Mampal, then we have Brigadier General Camilo, as well as Mading Riek Yak, and then Dominic Gatkok Riek. All of them are there and awaiting the process to commence. This is to ensure that the process of hearing by government or the legal team, you've seen the legal team, are now getting on the stage. These are the presiding judges, 3 presiding judges, as you could see, viewers. They have taken over their seats, and from here onward, of course, we will get to hear more. It seems that family members of the accused are already there, and we have government officials attending this event.
Be seated.
Yes, viewers, the 3 presiding over judges have already arrived, back to where we say that the culmination of this event is due to the fact that Nasir incident that took place back in the days, that is in March, and this will be the turning point in the judicial system of the country to ensure that rule of law is put into place, and those who are against the law are actually judged accordingly. And if they are proven innocent, that is what will happen. As what is going to happen, we'll be hearing what is happening as the accused already arrived, and the judges, presiding over judges, you've seen them at Freedom Hall. And back, the government made it clear that rule of law must be upheld too, or people must adhere to the rule of law. The essence of the rule of law is to ensure that people respect the rule of law and adhere to it. Viewers, let's connect you to our colleague as the proceeding commences at Freedom Hall. Stay tuned with us in this live broadcast on the special court.
First of all, we would like to start by serving the parties the order of the establishment of the court. The step number 2 is that we would like to read out the audience ground rules. First of all, before the beginning of the proceedings, we would like to be reminded there that the law provides for public trial, meaning that the court is open to everybody. Including the media. However, the public has a duty to keep peace in the courtroom. Therefore, there is need to comply with the following. Number 1, the media houses are required not to conduct themselves only in accordance with the national laws. For instance, the Constitution, Media Authority Act, National Communication Act, Access to Information Act, Penal Code Act, National Security Act, and any other relevant laws in coverage and reporting. But also in accordance with the international law. Number 2, no movement while in the court. Nobody is allowed to move since he has entered into the court. Number 3, no talking in the court. You are not allowed to talk. You just listen. Number 4, phones shall be in silent. You will never be allowed to speak while you are in the court using your telephone. Number 5, no smoking in the court. Nobody is allowed to smoke. The court may send away any media apparatus or any person who fails to observe the above requirements and may decide to go for closed proceedings or take legal measures against anyone who is not able to adhere to the law. Thank you. Now we start the process, and I hope all the parties are in their places. The prosecution is there and the defense is there, because the court is going to take your attendance.
I wanted the attendance of the parties.
Honorable Court, this is Denga Ashwil Adija, Consul General on Prosecution Panel.
Good morning, Dr. Sobriwani Lado, Consul General, Minister of Justice, member of the Prosecution Panel. Thank you.
Good morning. My name is Serafino Simon Mezan, Consul General in the Minister of Justice, member of
your voice, please.
Serafino Simon Mezan, Consul General in the Minister of Justice, member of the panel. Thank you.
Filberto Mayuot Marang, Consul General in the Ministry of Justice on the Prosecution Panel. Thank you.
Advocate Ajo Onyoaisa, a member of the Prosecution Panel.
Advocate Gabriel Mading Apach, a member of the Prosecution Panel.
Judge Advocate Deng Mabur Deng, member of Prosecution Panel.
Ustaz Phillips Anyangong, member of the Prosecution Panel.
Who?
Phillips Anyangong, member of the Prosecution Panel.
Ajak Mayul Bur, Your Honor, member of the Prosecution Panel. Advocate Ajak.
Advocate Martha Jobe Jeremiah, member of the Prosecution Panel.
My Lords, my name is James Bond Michael, member of the Prosecution Panel.
I am Advocate Peter Garang, member of the Prosecution Panel.
Second Legal Counsel, Your Honor, Botrus Yai Adio, member of Prosecution panel.
Brigadier John Zak, Investigator, member of Splm.
Major General Basilio Thomas Wani, investigator. Basilio Thomas Wani, investigator, member of the Prosecution panel.
Captain, Legal, Security, Richard Kashif, Apollo, behalf of National Security Internal Security Bureau, complainant.
Please repeat.
Captain, Legal, Security, Richard Kashif, Apollo Musa, behalf of National Security Service, Internal Security Bureau, complainant.
Good morning, Your Lordship. Advocate Dr. Gary Raimondo Lege Lubate, the lead defense team. Thank you.
Please speak one by one.
Advocate Dr. Gary Raimondo Lege Lobate, the lead defense team. Thank you.
Next.
Bismillah ar-Rahman ar-Rahim. Al-Ustaz Kur Lual Kur al-Muhami, عضو هيئة الدفاع.
Ustaz Anis Tombe Agustino, عضو هيئة الدفاع.
Repeat, please.
Ustaz Anis Tombe Agustino, عضو هيئة الدفاع.
حضور الأستاذ دينغ جون دينغ، عضو هيئة الدفاع.
Who?
دينغ جون دينغ. الأستاذ دينغ جون دينغ، عضو هيئة الدفاع.
Next.
بحضور الأستاذ وارنيان كير وارنيان، عضو هيئة الدفاع. وارنيان كير وارنيان، عضو هيئة الدفاع.
عليكم. روجينا أكريودين، أستاذة روجينا أكريودين، عضو في هيئة الدفاع.
Next.
شكرا مولانا.
The accused persons.
Pot Kang Chol.
The voice is not clear, please.
Pot Kang Chol.
Mam Pal Dwar.
Yes, not clear.
Mam Pal Dwar.
Gadwech Lam Poch. Gadwech Lam Poch.
Camilo Gatmai Kel. Camilo Gatmai Kel.
Riek Machar Teny.
Lieutenant General Gabriel Duop Lam.
Please repeat.
Lieutenant General Gabriel Duop Lam.
Mading Yak Riek.
Mading Yak.
Mading Yak Riek.
Next.
Dominic Adgo Riek.
We have done with the attendance, and then now we would like to proceed for the two parties, whether there is any observation. Is there any observation from each of? Yes.
Your Lordship, we have an objection for establishment of this Honorable Special Court by His Lordship, the President of the Supreme Court of the Republic of South Sudan, Honorable Justice Dr. Benjamin Bagding, to constitute this special court for the following grounds. His Excellency Dr. Riek Machar Teny is governed by the provision of Article 103 read together with Article 104 of the Transitional Constitution of the Republic of South Sudan, read together with the provision of regulations, conduct of business regulations, which I read. This is here. Transitional National Legislature Conduct of Business Regulations 2013 as amended 2021, read together with the revitalized agreement signed on 12th of September 2018, read together with incorporation of this revitalized agreement into our Constitution's Amendment number 6, 2020, His Excellency Dr. Riek Machar Teny, the first Vice President of the Republic, should not be tried by this incompetent court which lacks jurisdiction. First and foremost, Article 103, Clause 2 of the Constitution pertaining the immunity and impeachment of His Excellency, the President of the Republic of South Sudan, in case of impeachment, and the same provisions applies to His Excellency, the first Vice President, Dr. Riek Machar Teny, plus the other 4 Vice Presidents. This is read together with provision of regulations number 63 of the Transitional National Legislature Conduct of Business Regulations 2013, amended 2001. And it is good. We thank this Honorable Court because our first prayer is supposed to be the warrant of establishment of this Honorable Court, which is stipulated in Article 126, which avail His Lordship, the President of the Supreme Court, to establish any court. Your Lordship, this court is not for people like His Excellency Dr. Riek Machar Teny, who is governed by a revitalized agreement, and this court is supposed to be, impeachment of His Excellency is supposed to be in accordance with the Article 103, Clause 2, should be through passing a resolution by 2/3 member majority of the national legislature, which is stipulated here and in the Constitution. And for us, we were really, thank you, my colleagues, for the dream we have done. It is already here. We have done this. And this is what our defense. Let me read. It is here. What did it say?
So this is the objection in writing, Mr.
Yes, this is objection in writing. I'm going to read to the Honorable Court because we are making history to this Republic
It's
of
okay,
South
it's
Sudan.
okay, that's good.
Thank you. It is a history. And it is our time to do that. The Republic of South Sudan, the judiciary, in the special court for Nasir incident at Juba 2025, in the matter of trial of accused, His Excellency Dr. Riek Machar Teny and 7 others, criminal case number 1533 of 2025, brought under sections 48, read together, sections 50, 52, 60, 61, 64, 65, 66, 67, 70, 71, 72, 75, 76, and 2006, which is the mother, and section 239 of the Penal Code Act 2008, read together with section 15A, B, and 16 of Anti-Money Laundering and Counter-Terrorism Act 2012 as amended 2024, subject. Objection on lack of jurisdiction of a special court to try His Excellency Dr. Riek Machar Teny, and the first Vice President of the Republic of South Sudan, and his colleagues, the 7 accused. Your Lordship, Honorable Justice, the President and members of the Special Court, we act for and on behalf of the accused, His Excellency Dr. Riek Machar Teny, the first Vice President of the Republic of South Sudan, as the first accused, put Kang Chol, our Minister of Petroleum, number 3, Lieutenant General, put Gabriel Dub, number 4, Mam Pal Dor, and my age mate, my colleague, Garwich Lam Foj, number 6, Brigadier General Camilo Gadmal Kel, Mading Rek Yak, and Dominic Gadrog Riek, respectively. We submit this preliminary legal objection to this Honorable Special Court, challenging the jurisdiction and competency of this Special Court to try the above accused person on the ground of revitalized agreement on the resolution of the conflict in the Republic of South Sudan, and also constitutional immunity to His Excellency Dr. Riek Machar Teny Dorgen, the first Vice President of the Republic of South Sudan, and constitution establishment of this special court by the Honorable Justice President of the Supreme Court of the Republic of South Sudan, and violation of international treaties, conventions which South Sudan has assent, and regional human rights norms. 1. Ground for legal objection: supremacy of the revitalized agreement on the resolution of the conflict in South Sudan, 2018. The revitalized agreement on the resolution of the conflict in the South Sudan is binding upon the government under both constitution and international laws, and superior to the constitution pursuant to provision of Article 8, Clause 3 of the revitalized agreement, which is stipulated. This revitalized agreement shall take precedence over any national legislation, any existing agreement to the contrary, and in the event that the provision of a national legislation or previous agreement conflict with the term of this agreement, the provision of this agreement shall prevail. As a matter of binding constitutional incorporation, the revitalized agreement on the resolution of the conflict in South Sudan under Article 5, Clause 3, Paragraph 1, Subparagraph 1, provide for the establishment of hybrid court for the South Sudan, which is stipulated that there shall be established an independent hybrid judicial court, the hybrid court for South Sudan. The court shall be established by African Union Commission to investigate and, where necessary, prosecute individuals bearing responsibility for violations of international and or applicable South Sudanese laws committed from 15 December 2013 through the end of the transitional period. Your Lordship, crucially, the hybrid court for South Sudan constitute the sole judicial forum visited with jurisdiction under the revitalized agreement to entertain allegation of violation of international law and other grave breaches of the laws of South Sudan attributable to the parties to the agreement. Consequently, if the Nasir incident is to be characterized as transcending a mere ceasefire violation and amounting to a serious crime within the purview of international or national laws, then the matter falls squarely and exclusively within the jurisdiction of the hybrid court, which has never been established by the African Union Commissions of Human Rights. Your Lordship, the hybrid court has been designed and agreed to have its own bill, investigations, and prosecution mechanism. This is what His Excellency Dr. Riek Machar and his colleagues and the rest have agreed. Just as the revitalized agreement has primacy over all laws of South Sudan, including our beautiful constitution here, this beautiful constitution here, our constitution, the hybrid court is also envisaged to have primacy over all the national courts with regard to investigating and prosecuting serious crimes under international law and relevant laws of the Republic of South Sudan, which involve parties or individuals within the parties to conflict during the transitional period, as in the case under Article 5, Clause 3, 2 and 1, and Clause Article 5, 3, 2, 2 of the Revitalized Agreement 2008, read together with the provision of Article 201A, Clause 7, Paragraph A, B, C, and D of the Transitional Constitution of Republic of South Sudan, Amendment number 6, 2020, which is here. It is already here. It is respectfully submitted that the office of His Excellency, Dr. Riek Machar Teny, it is respectfully submitted that the office of His Excellency, Dr. Riek Machar Teny Dorgon, our first Vice President of the Republic of South Sudan, as the first Vice President of the Republic of South Sudan, together with the positions occupied by the 7 co-accused persons, derive their legal and constitutional legitimacy directly from Article 1, Clause 7 of the Revitalized Agreement on the resolution of the conflict in the Republic of South Sudan. Your Lordship, by virtue of these provisions, their offices and the mandate are a product of the peace agreement, which form an integral part of the constitutional and governance framework of the Republic of South Sudan. Your Lordship, basically, any purported criminal prosecution of the said offense barriers outside the mechanism expressly provided for under the Revitalized Agreement amount to a fundamental infringement, violations, transgressions of the agreement undermines and delicate process of peace agreement which we are yearning into, all of us in this hall and those who are outside. We were yearning into peace. We need peace in our country. We need reconciliations in our country. We need healing in our country. We need peace. Once again, Your Lordship, delegate any constituted breach, anything inconsistent with this agreement, which is incorporated into our constitutions by the heart of the people of South Sudan, constitute a breach of South Sudan and international obligations. We have an international obligation. Your Lordship, the provision of Article 8, Clause 3 of the Revitalized Agreement provides unequivocal terms that the provision of the agreement shall take precedence over any provision of the Constitution, Transitional Constitution of the Republic of South Sudan, and any other legislation of South Sudan which may be inconsistent with it. Likewise, this obliges all organs and institutions of government to implement and comply with the agreement in both letter and in spirit. Furthermore, the provision of Article 9, Clause 3 of our beautiful constitutions of Republic of South Sudan, 2011, as amended, provides that all rights and freedom enshrined in international human rights treaties, conventions, and instruments ratified or acceded to by the Republic of South Sudan shall be integral part of this beautiful constitution. Your Lordship, these constitutional provisions elevates the revitalized agreement as ratified international peace agreement to the status of supreme law. The supreme law, the Constitution, it is the supreme law, it is the grand norm, it is the mother of the laws which all of us in this hall and outside we are binding to upon all authorities, including the judiciary of Republic of South Sudan and the Minister of Justice and Constitutional Affairs and our Minister of Interior and the National Security. All of you, your duty mandate by this agreement, it is above all of us. All of us, we are down of it, and this is the one governing our country, international. Since South Sudan, Your Lordship, we are members of UN, as well as we are members of African Union, as also we are members of IGAD, and we are members of Northern Corridor, and also we are partners of East African Community, and you know, Article 6 right together with Article 7 of establishment of East African Community stipulates adherence to fundamental rights, rule of law. In light of the foregoing, any criminal proceeding instituted against His Excellency, Dr. Riek Machar Teny, our first Vice President of the Republic of South Sudan, or the co-accused who are here, outside the framework of the revitalized agreement, particularly in this regard of the hybrid court for South Sudan, envisaged under Article 5, Clause 3, 1 of the agreement, are ultra-various, beyond the power even of the Chief Justice. Above, it is unconstitutional, it is illegal, it is unlawful, and therefore it is null and void ab initio, without any legal effect. Therefore, they continue pursuant of this trial by this Honorable Special Court, which I respect it properly. I respect this Honorable Court. Constitute trial. The constitute process of this trial before this Special Court not only lacks jurisdiction foundation, but also places the Republic of South Sudan in manifest breach of its obligation under both domestic and international laws. For the avoidance of doubt, the revitalized agreement signed on 12 September 2018 in Addis Ababa remains valid and binding, and no derogation therefrom is permissible without express and formal abrogation in accordance with due process of the law. Number 2, jurisdictional and procedural objections on constitutional immunity of His Excellency Dr. Riek Machar Teny, our first Vice President of the Republic of South Sudan. First and foremost, we want to bring to the attention of this Honorable Special Court that the instance of preliminary legal objections pertaining one of jurisdiction of this Honorable Special Court is that the legal objection meant to terminate an FRC or as well to nip it in the bud without wasting the time dispersing unnecessary energies in considering unworthy or fruitless matter in the court proceeding. It, in other words, forecloses hearing of the matter in order to save time. Your Lordship, Article 103 and Article 104, Clause 2 of the Transitional Constitution of the Republic of South Sudan as amended, read together with the provision of Regulation 62 and 63 of the Transitional National Legislature, which is here. This is our Constitution, and this is here. This one. Read together with the provision of Regulation 62 and 63 of the Transitional National Legislature, Conduct of Business Regulation 2013, amended 2021, provided that the first Vice President shall not be subjected to criminal proceeding while in office. Except upon proper removal of immunity upon a resolution passed by a 2/3 majority of all members of the National Legislature. Article 104, Clause 2 of our Constitution read as follows. The Vice President may be removed by the President or by 2/3 majority of all members of National Legislature. The provision of Regulations 62 and 63 of the Transitional National Legislature Conduct of Business 2013 as amended 2021, entitled Immunity and Impeachment of the President, the First Vice President, and the Vice President. Regulation 62 read as follows. Impeachment of the President. The President shall be immune from any legal proceeding and shall not be charged or sue in any court of law during his or her tenure of office. 2. Notwithstanding sub-article 1 above, in case of high treason, gross violation of this Constitution, or gross misconduct in relation to national affairs, the President may be charged before the Constitutional Panel of the Supreme Court in the Republic of South Sudan, and upon a resolution passed by a 2/3 majority of all the members of the Assembly. Clause 3, the President of the Supreme Court shall within 7 days after receipt of the impeachment notice referred to under sub-article 2 above, constitute a tribunal comprising 3 justices of the Supreme Court to evaluate the allegations in the notice and to report to its findings to Constitutional Panel of the Supreme Court. Number 4, Clause 4. The President shall be entitled to appear at the proceeding of the tribunal and to be represented by a lawyer or other expert or any other person of his or her choice. Number 5, if the constitutional panel convicts the president, it shall communicate its final verdict to the assembly, and he or she shall be deemed to have fulfilled the office. Your Lordship, this provision is applicable to His Excellency, the first Vice President, according to provision of regulation number 62, 63 of the Transitional National Legislature Conduct of Business Regulations 2013 as amended 2021, which read as follows. Regulation 33, removal of the first Vice President and the Vice Presidents. The provision of Regulation 62 shall, with necessary modification, apply to in respect of the first Vice President and the Vice President. The question arises here is, when does a court become competent? A court becomes competent when it is properly constituted as regards members and qualifications of the members of the bench, and no member is disqualified for one reason or the other. Number 2, the subject matter of the case is within its jurisdiction, and there is no forfeiture in the case which prevents the court from exercising its jurisdiction. And 3, the case comes before the court initiated by due process and upon fulfillment of any condition precedent to exercise of the jurisdiction. My Lord, Your Lordship, any defect to these 3 points on competence of the court is fatal. For the proceeding are nullity, however well conducted and decided. The defect is extrinsic to the adjudications. For the above legal points 1, 2, and 3 go together in the circumstances of the instant case, the 3 points were not fulfilled for the following ground. 1, the Honorable President of the Supreme Court of South Sudan has no jurisdiction to constitute a special court in case of the first Vice President, His Excellency Dr. Riek Machar Teny, our first Vice President of the Republic of South Sudan, which is subject to impeachment upon resolution passed by a 2/3 majority of all members of National Legislative Assembly, provided in the provision of Article 104, Clause 2 of the Constitution of South Sudan, read together with the provision of Regulation 62 and 63 of the Transitional National Legislature Conduct of Business 2013 as amended 2021. Therefore, the order of establishment of this Honorable Special Court by Honorable the President of the Supreme Court of South Sudan is ultra vires, beyond its mandate. It is unconstitutional, it is illegal, it is unlawful. Therefore, the sitting here is wasting of resources and time. That beyond his jurisdiction for him in the provision of section 16(4) of the conduct of our criminal code of procedure. The only power of our President of the Supreme Court is only to constitute or to establish a special court for trial of juvenile offenders. These are not juveniles. To form high court to preside, convince or preside, a special court to be presided over by the High Court or any senior justice, which is not the case here in the case of the first Vice President. And number 3, a High Court judge may convince a special court. This is not relevant. It is irrelevant. So, which is stipulated that the President of the Supreme Court may, by order, constitute a special court for the trial of any accused under chapters 4, chapter 5 and 7 inclusive of the penal code. Number 2, lack of a resolution passed by 2/3 majority members of all members of the Transitional National Legislature Assembly as provided in Article 104, Clause 2 of the Transitional Constitution, read together with the provision of Regulations 62 and 63 of the Transitional National Legislature Conduct of Business 2013 as amended 2021. Therefore, the arrests and detentions of the first accused, His Excellency Dr. Riek Machar Teny and his brothers, were carried out without lifting the immunity, rendering this proceeding unconstitutional, unlawful, illegal, and void ab initio. The right to be tried before a competent court, independent and impartial tribunal is guaranteed under both international treaties ratified by the Republic of South Sudan and the Bill of Rights in Part 2. Bill of Rights is here in Part 2 of our beautiful Constitution, from Article 9 through Article 34 of our Constitution. It is about the Bill of Rights, it is about human rights, it is about the due process of the law, it is about the crack of the whip. Number 3, relief sought. Wherefore, His Excellency Dr. Riek Machar Teny and the 7 accused persons respectively pray this Honorable Special Court to order in their favor as follows. Number 1, order this Special Court lacks of jurisdiction and competence to try this matter, and therefore null and void ab initio pursuant to the absence of fulfillment of the requirement stipulated in the provision of Article 104, Clause 2 of the Transitional Constitution, read together with the provision of Regulations 62 and 63 of the Transitional National Legislature Assembly Conduct of Business 2013 as amended 2021. Number 2, order the immediate discharge, release, and go home of His Excellency Dr. Riek Machar Teny and his brothers from this court, and let them go home from today. Let them go home and have the business to do their job. Order the immediate discharge of His Excellency Dr. Riek Machar Teny, the first Vice President of the Republic of South Sudan, and the 7 accused persons for being arrested and detained unconstitutionally. Number 3, Your Lordship, any other relief this Honorable Special Court deemed fit, respectively submitted, date today, 22nd day of September 2025, Defense Advocate Dr. Gary Raymond Lege Lobate, the lead advocate. Number 2, Advocate Kurlwal Kur, member. Number 3, Advocate Deng John Deng, member. Number 4, Warnyang Kir Warnyang, member. And finally, Advocate Anis Tombe Agustino, member. All, thank you so much. Thank you, my Lordship.
After hearing the application of the defense, now we would like to give chance to the prosecution to reply.
My Lord, allow us to reply to our colleague, Dr. Gary, for what he has raised of his objections. This will be represented by one of the panel, Advocate Newell. May he
Your reply will be in writing or verbally?
we will make it because my lords will give an oral reply and we'll give you a snapshot of our reply.
And then you...
Yes, we'll give you a snapshot
and then
in writing.
Okay.
Yes. May it please this court, my Lord Justices of the Special Court. I will go slow so that we are able to record our submission in reply to the petitioner objection raised by the defense team. My Lord Justice of the Special Court, I will start with ground number 1 of the legal objection.
My Lordship, we object to these oral submissions. We are making history. Your Lordship, we object these oral submissions. We are making history. The Republic of South Sudan is making history. We need all things to be in written form so that we put in record for this country. 2, we object the appearance of the private advocate because, as we have heard from our colleague from the security, the complainant, the appearance of any private advocate there is inconsistent with the provision of Article 133 of our constitutions of Republic of South Sudan, which shoulder all this responsibility under the Minister of Justice. Not any person else. Let me read to you. Article 133, clause. Article 133, clause 3. Yes. Which is part 8 of our constitution. The public attorney and legal advisor shall be under the National Minister of Justice and Constitutional Affairs. Clause 3. Public attorneys and legal advisors shall advise all. No. The Minister of Justice shall be the chief legislative The Minister of Justice shall be the chief legal advisor and the prosecuting authority at all levels of government and shall perform such other functions of legal nature as may be prescribed by law. Number 3, public attorneys and legal advisors shall advise all levels of government, represent them in public prosecution, litigation, adjudication, and conduct free trial proceeding. They shall recommend reform, strive to protect public and private rights, advise on legal issues, and shall render legal aid. This is a constitutional requirement. It is mandatory. It is peremptory. If we are not in a state of emergency, there is no any state of emergency which allow private lawyers to come. They are all there and they are competent to do the job, not anyone who is private. That is why we are here. Therefore, I call upon this honorable court to send them out to sit outside there with our brothers who are sitting there, and because to appear in this honorable court is a constitutional right, we don't object on that. They can move from here and sit with our brothers and sisters who are outside there. Thank you, my Lord.
Okay. Let us separate between two things. You see, you are now like raising another point of objection, which is, in our view, will be a separate point. As for the reply, we think, as they told us, that they will provide a written reply, and now he's giving us the summary of that reply. Please continue.
Thank you. Thank you, my Lord. I would proceed to provide our response to the defense objection. My Lord Justice, the first ground of legal objection is on the supremacy of the revitalized agreement on the resolution of conflict in South Sudan, 2018. It is the argument that the revitalized agreement shall take precedence over any national legislation, any existing agreement to the contrary, and in the event that the provisions of a national legislation or previous agreement conflict with the terms of this agreement, the provisions of this agreement shall prevail. My Lord, this argument finds no basis in law. First, there is no conflict between the revitalized agreement and the law, so as to invoke the provision of Article 8.3 of RCS. My Lord, in terms of competence of this court to try the first vice president, it is a prosecution argument that this court is competent to try the first vice president. My Lord, presiding justice and justices of the special court, Article 123E establishes the structure and hierarchy of a judiciary. And under E, it empowers that there shall be established other courts and tribunals as deemed necessary to be established in accordance with the provision of the Constitution and other law. This provision of the Constitution is reiterated, my Lord Justices, in Section 7F of the Judiciary Act 2008. As to the rules that shall apply to such other court as shall be established, my Lord Justices, Section 9 of the Judiciary Act provides for the same. In terms of paneling of these special courts, my Lord Justice, Article 126(3) of the Transitional Constitution 2011 as amended provides for paneling of special courts, that in case of criminal or civil matters, there shall be in panels of 3, and when they sit as a constitutional panel, there shall be at least 9 justices, where the Chief Justice shall be presiding. The same provision is reiterated in Section 11(3) of the Judiciary Act. It is based on this narrative and sequence of law, my Lord Justices of the Special Court, that this Special Court is established by this order of establishment, referenced as JOS, in -CJ, J, AO, 1, 2025, dated 1st September 2025. Under Section 16(4) of the Code of Criminal Act, it provides that the President of the Supreme Court may, by order, constitute a special court for trial of any person accused under chapters 5 and 6 of the Penal Code Act. My Lords, as you might have seen in the charge sheet, the offenses with which the accused persons are charged are all under Chapter 5 and 6 of the Penal Code Act, which are offenses relating to offenses against South Sudan, as well as offenses relating to the armed forces of the Republic of South Sudan. The same provision, the same reality is reiterated in Section 44 of the Code of Criminal Act, empowering the Chief Justice to constitute this special court. My Lord Justice, the arguments that this court lacks competence to try the first Vice President by virtue of Article 126G of the Transitional Constitutional Republic of South Sudan 2011 as amended. These claims, my Lord, are unfounded. This article provides that the Supreme Court shall exercise competencies as follows: have criminal jurisdiction over the Vice President, the Speakers of the National Legislative Assembly, and of the Council of States, and the Justices of the Supreme Court. It is the assertion of the defense that based on this court, the special court is not a Supreme Court and therefore lacks competence to entertain this matter. My Lord, this argument is weak and lacks substance. The members of this special court are all justices of the Supreme Court and therefore competent to entertain the matter by virtue of the laws as stated. Even if the powers given are powers of the High Court has unlimited jurisdiction. And therefore the crimes committed based on Chapter 5 and 6 are within the competence of the High Court powers. My Lord, there is an argument from the defense team that Article 126G deals with the office of the Vice President. We argue that Article 126 deals with the office of the Vice President. The fifth accused is not the Vice President, but the first Vice President. It is the argument, of course, that under Article 1042, he is not to be impeached. This is their language. He is not to be removed by virtue of Article 1042 unless there is a decision passed by 2/3 majority of all members of the National Legislative Assembly. My Lord, this is a misdirection to this court. This is not a session to remove the first Vice President. This is not a session to impeach the first Vice President. This is a court proceeding within the competence of the Judicial of the Republic of South Sudan and has nothing to do with his office or removal from office. Notwithstanding this argument, my lords, allow me also to assert this, that Article 126G deals with the office of the Vice President. The fifth accused person is not the Vice President, but the first Vice President. His office is a creation of RSS, and by virtue of Article 1.4.3.5 of RSS. It was incorporated in the Transitional Constitution of the Republic of South Sudan through the Transitional Constitution of the Republic of South Sudan Amendment number 6 of 2020. Article 104 establishes his office. Article 104A and Article 104B designate his powers, functions, and responsibilities. My Lord, Article 126G of the Transitional Constitution was not amended specifically by inserting the word first Vice President in the text to reflect this new reality. If it was intended by RSS or the National Constitutional Amendment Committee, the amendment would have occasioned such. For instance, in the amendment number 6 of 2020, Article 92 of the Constitution was amended by inserting the words first Vice President, for Vice President between the words President and the words National Council of Ministers. The fact that this was not done with Article 126G of the Transitional Constitution means that it was not intended to cover the first Vice President, hence the competence of this court to entertain this matter. My Lord Justices, there is an argument on the immunity of the first Vice President. The defense claim of immunity, my lords, is legally bankrupt within the framework of South Sudan laws. It finds no support under Article 103(1) of the Transitional Constitution or the Revitalized Agreement on the Resolution of Conflict in South Sudan. First, my lords, immunity provided for under Article 103 is for the President and is in clear black and white. Only for the President and not for the Presidency. The amendment number 6 of the Constitution in the interpretation provision defines presidency to mean, that is section 3 of the amendment, Constitutional Amendment Act number 6 of 2020, defines presidency to mean the President himself, the first Vice President, and the 4 Vice Presidents. However, goes ahead to define the President to mean the President of the Republic of South Sudan. These definitions, as stipulated in the Constitution, my Lord Justices, clearly demonstrate the fact that the two are different and distinct. Immunity is a creature of statute and law. Notwithstanding this, immunity is not an absolute privilege. Even the President of the Republic can suffer a charge in cases of high treason, gross violation of the Constitution, or gross misconduct in relation to national affairs if there is a resolution passed by the National Legislative Assembly. Secondly, my lords, under the Revitalized Peace Agreement, this argument has no legal basis. Article 1.4.3.5 of the Revitalized Agreement, Article 1.4.3.5 of the Revitalized Agreement provides for the incorporation of the Revitalized Agreement into the Constitution. This was occasioned by amendment, the Transitional Constitution of the Republic of South Sudan Amendment Act number 6 of 2020. So by that act, the Revitalized Agreement became part of the Constitution. My lords, when this amendment was done, Article 103 as a whole was not amended to extend the immunity to the presidency as a collegial body, but maintained as a privilege to be enjoyed by the President of the Republic alone. If it was intended to cover the first Vice President or the other Vice Presidents in the presidency as claimed, Article 103 would have been amended when the RCS was being incorporated into the Constitution. That was not done. My lords, the lead defense counsel, Dr. Gary Raimondo Lege Lobate, further proceeded to bring provisions under the Transitional National Legislative Conduct, Transitional National Legislature Conduct of Business Regulation 2013, amended 2021. Specifically, rules 62 and 63. My Lord, with due respect, these are irrelevant provisions. Provisions that has no bearing with the matter before us. Provisions that speak to how we do not take this matter with the seriousness it deserves. Provisions that speak to us not taking zealously our obligation to prosecute a case. My Lord, before we conclude our response to defense preliminary objection, allow me to give the mic to my senior, Philberto Manuat, to respond on the matter of hybrid court competence in this particular matter, and not why this special court.
My lords, justices of this honorable special court, I will take the response to the argument for the hybrid court to be the competent court for the trial of the offenses for which the accused is stand to be tried. Let us first assert that the special court is one of the courts under the judiciary of the Republic of South Sudan, constituted by the Chief Justice, who has authority under the national constitution to constitute such courts. Now, the argument for the hybrid court to be the competent court for the offenses brought against the suspects standing before this court tantamounts to advocacy or advocation for impunity to prevail in the country. Why? Because South Sudan is a sovereign country having a functional government, and it is having the responsibility of providing security to its people. Now, do we have to just wait for a court that is to be constituted by African Union to investigate and prosecute cases specified therein, when acts amounting to gross violations of the laws of the land have been committed, abetted, conspired for by some of the actors who are signatories to the RRCs. Now, it is very clear in the charge sheet that the offenses that have been brought forward against the suspects include offenses of mass murder and offenses related to terrorist activities. Now, can we say that Nasser incident, which was orchestrated or basically carried out by the so-called White Army and not the SPLA as a signatory to the RRCs, can be left for hybrid court, which is to be constituted? In summary, My lords, it is our conviction that this special court, having been constituted by the Chief Justice, using his powers as stipulated under the Constitution, is competent to try the accused before it, including the first Vice President, Dr. Riek Machar. Thank you.
My Lord Justices, in summary, my senior asserts that the Hybrid Court under Article 5.3, under Article 5.3.2.1 of RSS prescribes and restricts the jurisdiction of the Hybrid Court to crimes of genocide, crimes against humanity, and war crimes, and other serious crimes under international law and relevant law of the Republic of South Sudan, including gender-based crimes and sexual violence. My lords, these offenses are not in Chapter 5 and 6 of the Penal Code Act. My Lord, it is therefore our prayers, given these arguments, in response to the defense preliminary objection, that this honorable court dismisses the defense objection as misconceived, misunderstood, misleading, and contrary to the statutory and constitutional mandate of this court. To affirm the confidence of this court to proceed with the trial. I rest my case. We will serve some highlight drafts on, you have already served, and then the defense team. Okay. We rest our case, my lord.
Your chance, the defense.
Your Lordship, Honorable Justices of this special court.
Excuse Dr. Giri.
Thank you, my colleague.
We are asking the prosecution, when will they bring their response in writing before you continue? Let them
Your Order, we have given them copies of our snapshot. If you want detailed one, we can provide by after lunch, if it's needed, or even tomorrow morning. So if you don't mind, give us until tomorrow morning, we can provide, because we have details of maybe case laws, which we need also to print out and share for the consumption of this honorable court.
You must submit full defense, reply, please.
Most obliged, my lord.
After lunch?
Tomorrow morning.
Tomorrow morning.
Most obliged, my lord.
Yeah, so this is Dr. Giri. You wait for their reply so that you continue tomorrow.
I do agree with the Honorable special court, because we are not in hasty. We are laying a foundation to this country, the rule of law. And
thank you. Now, the session is going to be adjourned for tomorrow, the same time. Please. Arfa Jalsa.
Go!
نعم أيها السادة والسيدات في كل مكان، أنتم تتابعون البث المباشر لSSBC لجلسة الأولى لمحاكمة أو جلسة الاستماع الأولى لمحاكمة دكتور رياك مachar النائب الأول لرئيس الجمهورية الموقوف وسبعة من المتهمين في قضايا تتعلق بالقتل الجماعي، الإرهاب، تمويل الإرهاب وتدمير الممتلكات العامة والعسكرية، وذلك تباعا لأحداث الناصر. وهذه الجلسة تم تأجيلها ليوم غد إن شاء الله في تمام 9 صباحا، وذلك انتظارا لرد هيئة الاتهام. وكان هيئة الدفاع قد رفع اعتراضا لإقامة هذه المحكمة نسبة لعدد من الأحكام حسب لجنة الدفاع يتعلق بعدم دستورية هذه المحكمة، لكن هيئة الاتهام أشار إلى أن هذه المحكمة أقيمت طبقا للدستور الانتقالي لجنوب السودان، وأيضا اتفاقية السلام المنشطة التي تم دمجها في الدستور الانتقالي. وهذه الجلسة سوف تتواصل ليوم غد في 9 صباحا. الآن آتي الميكروفون للزميلة ليلى عثمان وبقية الزملاء لمواصلة التعليق.
Thank you very much for tuning to SSBC. The court sessions has just ended. The session will be adjourned tomorrow for further hearing of this high-profile case involving Dr. Riek Machar and the 7 other accused colleagues. For more details, we'll keep updating you. Then let me give over to my colleague Martin Joseph for further details. Sorry, Mori.
Thank you, my colleague Leila Osman. Viewers and listeners of SSBC, to hear this first hearing of the session of the trial of Dr. Riek Machar, the suspended first vice president, and the co-accused have been adjusted for tomorrow due to some legal documents. Now decision will continue tomorrow because the legal defense team of the accused persons have raised some concerns on the illegality of the constitution of this court. They said the constitution, the special court to try this accused is illegal, and that the first vice president is still a sitting vice president. So based on the constitution of the Republic of South Sudan as amended, he's supposed to be tried by the Supreme Court, not a special court constituted by the judiciary. And the prosecution is saying that the special court constituted by the Minister of Justice has all legal rights. With this, let us go back to our studios with our colleague Gore Anthony. Gore Anthony, you are welcome.
In the first session of the proceedings and trial of the Dr. Riek Machar and 7 other accused that has been taking place at Freedom Hall since morning. We've been covering for you this event. This is in the fact that the government wanted everything to be on the public domain, that this matter has to be consumed by the public. For its nature, it requires attention of the public, and the public must know what has happened or what is happening in the country and how the government is trying to make sure that rule of law is kept or rule of law is adhered to by everyone who is part and parcel of this government or citizens of the Republic of South Sudan. Of course, the proceedings or the court is started by allowing the presiding over judges to give some rules and regulations of the court, of which was given to all those who happened to attend. And we do remember that the people who attended the court, including the accused, the defendant, and the prosecutions, all of them were attended the court process. And then we don't forget that families of those who are accused also happened to be part and parcel of this event or these legal proceedings that took place in Freedom Hall. Before the judge or the presiding over could actually adjourn the court for tomorrow, which is going to be on Tuesday, there was some proceedings, some process that were allowed for the defendant as well as the prosecution's team to be able to actually air out their point of view regarding the case at hand, the case of the accused and the co-accused, the suspended first vice president, as well as the suspended minister of petroleum, Potkang, as well as the other accused who happen to be some of them, which are including Mompal. We have Gabriel Doplam, we have Camilo Gatmai, we have Gabriel Doplam, including Madin Yak Riek and Dominic Gatkoth. Actually, all the accused happened or appeared before the court today, and in the attendance, they have registered their presence. This shows that the matter at hand will be given top priority, and the leadership and the country and the leadership of the country actually expresses so much confidence that this matter will be addressed and will always be given to the public for the consumption. Of course, during the court process, prior to its start or prior to its commencement, we have a number of prosecution team comprising of a number of lawyers and advocates, actually headed by Advocate Ajo Ohisa. Then we have Advocate Gabriel Madin, we have Advocate Deng Mabor, we have Advocate Philip Nyang, we have Advocate Ajag Mayol Bior, we have Advocate Jeremiah. More than 8 advocates from the prosecution team were present at the court today, and they have raised a number of concerns that will be also looked at by the defendant prosecution team. And on the other hand, the team of the prosecution or the team of the defendant that are being hired by the family of the accused or by the family of Dr. Riek, these are led by Advocate Dr. Gary Raimondo Lege, who happened to be the lead or the lead counsel of the defendant team, and include some of them in the list. We have also Advocate Kur Lual, member of the defense team. We have Advocate Anis Tombe Agustino, member of the advocate team, or member of the defense team rather. We have Advocate Deng John Deng, member of the defense team, and we have Advocate Wurnyang Kir Wurnyang, member of the advocate team. So then we have Regina Akero Deng, member of the defense team. They have raised a number of concerns, like some of you may have heard. They have especially given a concern that is a preliminary concern to the presiding over judges by saying they don't agree with the legality of the formation of the special court due to some of the articles that they have cited in the agreement, as well as the transitional constitution of the Republic of South Sudan. And the defense team, of course, during the proceeding or during the hearing, were given a chance that they will have to make a response to the defense preliminary objections of the constitution of the special court. This will be in writing, which will be tomorrow in the morning. The defense team is actually requesting that they should have some time to be able to articulate or write accordingly to what is actually based on the accusation. So based on the formation of the court, the defense team are saying they wanted a response to that. The presiding over judges, of course, has given ample time from now onward till tomorrow for the prosecution team, which is comprising of more than 8 advocates and some legal team. They will be able to respond to what the defendant team or defense counsel team required. And this will actually move us to the next session of the court, which has been done or which has been actually talked to by the judge or the presiding judges, who are 3 in numbers, and they have to make sure they go through this process until the accused, either they are being proved innocent or guilty as the process of the court continues. Once again, viewers of SSBC, back on the days, this culmination of this process is due to the Nasir incident that happened and resulting to the killing of more than 290 SSPDF soldiers, plus Major General who happened to die during that event, and Major General Majur, who happened to be killed during that event. With that, viewers will say that has finally brought us to this event or this coverage, live coverage of the special court proceeding or hearing for Dr. Riek Machar and the 7 other accused. Rule of law and fairness in trial and impartiality are the guiding principles to ensure that the rule of law is adhered to and the court bring to an end what has been happening. With that, all would say thank you for tuning into SSBC, and thank you to those who happen to join us. And SSBC will keep on updating you on what is happening with the court and with this special case. Thank you so much for joining us, and bye for now.